Good afternoon, everyone, and welcome to the latest in the Mills and Reeve construction team's foundations series of webinars. This is on executing documents, and um, that's something that sounds like it should be simple, but as hopefully Kiran, Della, and I will show you during the next 30 to 35 minutes, which should leave us plenty of time for questions. Um, it's not as easy a thing as you think it should be. If you do have any questions, please use the Q&A button on the screen. So I'll get us started by asking the philosophical question: what do we mean when we're executing a contract? And it's fair to say that Google was my friend in answering this question, and I've amalgamated a series of definitions from various online legal sources. And the sort of formal answer to the question is that execution is the means by which a party enters into a contract or deed by signing or sealing, and usually by dating, and by doing so gives effect to that agreement, that document in law. So what you're doing is you're recording the terms of your agreement, and you're taking the final steps to make that agreement, that contract, into a binding document. For those of you who may have studied contract law back in the day, what you are doing is effectively encapsulating all of the requirements that the law says there must be in order for there to be a valid contract: offer, acceptance, consideration, and intention to create legal relations. And arguably, executing a document is the most compelling evidence there is of the party's intentions to be bound and to create a contract. We're going to be differentiating between contracts under hand and deeds. And so what makes a deed a deed? And the answer is to be found in Section 1 of the snappily titled Law of Property Miscellaneous Provisions Act 1989. And that sets out the requirements of a deed. First, a deed must be in writing. It must be clear on the face of the document that it is intended to take effect as a deed. A deed must be validly executed as a deed either by the person making it, or if a number of people are entering into the deed, some or all of the parties entering into a deed. Now that allows for what lawyers refer to as originals and counterparts of deeds, and we'll come back onto that in a moment. And the document must be delivered as a deed. So what do we mean by delivery? Well, back in the day, it literally meant handing over the deed. So if there was a deed between two parties, the one party would sign the original of the deed, and the other party would sign the counterpart of the deed, and they would meet sort of in Victorian days in a coffee house in London to really lay on the imagery, and they would hand it over. So it tended to be that the seller signed the original and handed that over to the buyer, and the buyer signed the counterpart and handed that over to the seller. Both would then date the documents, and each would then have a deed with the other party's signature to it, confirming their agreement to the terms of the deal. Delivering a deed in the 21st century is a slightly more nebulous concept. The law says that the requirement for delivery is that there has to be a clear indication of an intention that the parties have to be bound by the deed. How do you show that? Well, in a number of ways. Certain contracts have a statutory presumption that the document, once it complies with the statute requirements, will be delivered. But for an awful lot of contracts, and for an awful lot of contracts that the transactional construction team at Mills and Reeve draft and negotiate and execute by way of deeds, we include wording of the type I've just put on the screen. this document is executed as a deed and was delivered when it was first dated. So that complies with two of the requirements for a document to be a deed. It makes it clear on the face of the document that it's intended to take effect as a deed, and it says that delivery happens when it is first dated. So Della in particular is going to talk about what happens when deeds go wrong, but what are the sort of common issues with deeds? The big one is dating. Now, this actually, the point we're about to make in relation to dating applies just as much to contracts under hand as it does to deeds. You date the document, you date the deed, you date the contract the day that it is dated. So if you have a contract in front of you today, the 2nd of April 2025, and you are dating it, you date it the 2nd of April 2025. What you don't do is backdate it. And sometimes people find that concept quite difficult and will say things like, hang on a minute, there are some obligations in this deed or in this contract that predate today's date. Well, that's fine, so long as the contract makes it clear that it governs those things which were done before today's date as well as subsequent to it, it's fine. What you cannot do is backdate it. There have been cases where backdating a deed has been considered to be fraud, and lawyers have been struck off for backdating deeds. I hope I've made the point sufficiently clear. Please don't backdate documents, don't backdate deeds, don't backdate contracts. The next thing, and Kiran's actually going to touch on this in more detail in the context of electronic execution of documents. Often, deeds require a witness to witness the signatory or signatories signing the document. And before the pandemic, and the pandemic is the ideal date to do before or after, if I'm honest, we never really bothered to check whether whether the witness did actually witness the signature. We just assumed that they did. I suspect that there may be documents out there where the witness signed it significantly after the signatory and wasn't in the room to witness it. But if there is a requirement either for the company in question or the university say that the signature is witnessed, the witness should be in the room to see that happening. Although query how often that happened in practice. And the final point that I'm going to touch on, and Della will come back to this question in one of the cases that she's talking about. If your deed is defective in some way, can it take effect as a contract? And without wanting to steal Della's thunder, the answer is possibly. It depends on the individual facts. And the key point to bear in mind is that the answer is possibly yes, if the underlying document fulfills the other requirements in order for it to be a valid contract. So offer, acceptance, consideration, intention to create legal relations. There are some documents, anyone who's bought or sold a house will know this, which require documents to be by deed. In that scenario, if there is a defective deed, then the underlying document, which the law says has to be by deed, won't be effective. And having set Della up for her explanation of a cracking case on that issue in a bit, I'm now going to hand over to Kiran, who's going to talk about the electronic execution of documents.
Thanks, Stuart. So, as Stuart said, my focus this afternoon is electronic execution, and this is something that I think we've all seen gain rapid revolution since, particularly the pandemic, and it's definitely continued to keep up that momentum, whether that's because it's environmentally friendly or for those last-minute urgent contracts that need signing there and then. Electronic execution does present some interesting quirks, particularly in the construction sector, where we typically deal with large volumes of contract documents. So we will also be discussing that as well. So what is electronic execution? At its core, it refers to the process of signing legal documents electronically rather than using your traditional pen to paper wetting signatures. Under English law, electronic signatures are legally valid and enforceable, and this was confirmed by the Law Commission's report in 2019, which stated that an electronic signature can be used to execute a document, including deeds, provided that the signatories intend to authenticate that document and any of the relevant formalities which Stuart touched on are satisfied. The report also went on to confirm that various forms of electronic signatures are recognised, and that can range from simply typing your name into a signature block to applying a formal e-signature using a dedicated platform like DocuSign. So there are many different platforms out there, such as Adobe Sign and Nitro Sign, but the one we'll be talking about today is DocuSign, as that's one of the most widely used platforms. Anyone can use it, provided that they just have an email address that the DocuSign envelope can be sent to. But bear in mind that those who sign by applying a common seal cannot use it unless they have an electronic seal that they can apply instead. The process itself is pretty straightforward. Essentially, the sender uploads the document and tags the relevant signature boxes, date boxes, and potentially initial boxes too. The recipients then receive an email link where it will take them to the DocuSign platform and they can review the document and apply their electronic signature. DocuSign is also really helpful in generating an audit trail, which is known as a completion certificate, which provides clear evidence of who signed and when. You should then ensure that that electronic document is filed electronically, and also critically that that completion certificate is filed alongside it. Some people choose to attach that certificate to the back of the document, but that's not always strictly necessary. So almost anything can be uploaded to DocuSign, Word documents, PDFs, Excel spreadsheets, amongst others. But there are file size limits to be aware of that can particularly be a pain for construction contracts. There's an individual file size limit of 25 megabytes and an overall envelope limit of 200 megabytes. So with the individual files, DocuSign is really helpful in rejecting straight away if you try to upload something larger than 25 megabytes. But be cautious with the overall envelope limit because sometimes it will let you upload the contract documents only then to fail when you actually press send. So you have to restart the whole process. So moving forward then to the quirks and considerations. Electronic execution has plenty of them, but we're going to highlight 4 key areas that frequently raise quite a few questions. And the first one, as Stuart mentioned, I'd be discussing is witnessing. The Law Commission, in the report I referred to a little earlier, said that whilst the signature can be electronic, the current law requires the witness to be physically present when the signatory applies their signature, even if the signature itself is electronic. So that means remote or virtual witnessing, such as through Zoom or Teams, is not currently valid. DocuSign does offer that witness functionality. So essentially, the DocuSign envelope gets sent to the signatory first, and once they've signed, it automatically forwards on to the witness to then sign as well. But as Stuart said, we never really knew before electronic execution was more widely used whether a deed was witnessed correctly in wet ink. But now there are ways with the platforms such as DocuSign to actually check this and verify this. So the first way that you can do that is as a timestamp when it shows what time signatory signed. So it'll be clear if there's quite a significant gap between when a director has signed, for example, and perhaps a witness has signed a day after. And the question then is raised of can we turn a blind eye to that, knowing that the chances are that has not been witnessed correctly. And that's why it's becoming increasingly common to impose timeframes for witnesses. And that can usually range anywhere between 30 minutes to also half a day. We at M&R in our construction team impose 2 hours. And the reason that we say 2 hours is we think it's reasonable to take into account any of the things that impact our day-to-day lives. So, for example, if a husband was witnessing his wife's signature, but before he has a chance to sign it, he has to run and sort the children out, but then manages to come back round to signing that document an hour and a half later, that should be valid because he was there when he physically saw his wife sign. He just by the time he was able to sign himself, it had just been a bit of time. So that time frame just builds in a little bit of comfort for situations like that. The second way DocuSign also allows you to check is it has options like geolocation, where you will actually pinpoint where the director and the witness were when they signed, so you can check if they were in the same location. So be aware that some people will be checking that also. The next point is two-factor authentication. So the Law Commission's report highlighted the importance of considering the security and reliability of electronic signatures. DocuSign offers various levels and different approaches to identity verification, including two-factor authentication. And that's essentially where the signatories will confirm their identity by inputting a code that has been sent to their own mobile phone in order to access, view, and sign the document. And unfortunately, it must be mobile phones and landlines are not accepted. This is something which most law firms will insist on, and the land registry as well has specific requirements when it comes to the electronic execution of deeds, specifically that signatories must be appropriately identified with strong ID verification. We do face issues of individuals not wanting to provide their mobile numbers, and we appreciate that. However, in these cases, we do reiterate that it's for security reasons and the mobile numbers are not used for any other purpose except DocuSign. But if this doesn't give the comfort it needs to, then we will always revert back to your traditional wet ink signature instead. And I think it's fair to say here that it's not us being difficult, but it's done for security and ensuring the validity of the deed. And we are insisting on this going forward, as we think most other law firms and organisations will be too. The third point is now zooming in on the construction sector specifically. And it's fair to say that we deal with particularly high volume of documents when issuing, for example, building contracts. A single project might involve not just the main building contract, but a schedule of amendments, collateral warranties, novation agreements, bonds, and the list goes on. So in hard copy, we would have used USB sticks or CDs or even bankers' boxes full of documents. However, to manage it effectively and efficiently on an electronic platform, and bearing in mind those file and envelope limits I discussed a little earlier, there are a few techniques we found particularly helpful. With our first approach, it's linking multiple envelopes. So for large construction transactions, it might be practical to split documents into manageable themed envelopes, say one for your building contract and amendments, one for warranties, one for the other contract documents. So that keeps control over the order and the process. We would then prepare a cover sheet that would sit at the start of each individual envelope, which lists not only the contents of that specific envelope, but also references all the other relevant envelopes as well, just to ensure that no document is missed. That cover sheet is then signed by all parties to acknowledge that all those documents form that big contract pack. This will always be the preferred method because all contract documents are then issued as part of the contract and collated at the very end, so there can be no argument as to which documents, which versions of documents are the right ones. However, practically speaking, it might not always be feasible to set up, 15 to 20 envelopes. So an alternative would be opting to have the signatories just sign a contract document schedule or index. So the full contract, of course, will be circulated for review and agreed beforehand, and those contract documents might be uploaded to a data room. But the actual execution is streamlined to just the key parts. So, for example, for a building contract, you might just look to upload the JCT contract booklet, the schedule of amendments, and then this contract document schedule or index. It is crucial that that final schedule clearly references all documents in as much detail as possible. So that's document names, numbers, revisions, and anything else. And it would also include some technical wording at the very end so that all parties confirm that they're signing the agreed version and that all of these documents have been seen, downloaded, and form part of the contract pack. And finally, one area that is cropping up more often now is the hybrid scenario, where one party will sign electronically, but the other insists on a wet ink signature, perhaps due to their own internal policies or, as I mentioned before, where they sign by seal and it's simply not possible to sign electronically. Legally, there's nothing to prevent part wet ink, part electronic execution, just provided that the formalities are satisfied and the parties agree on that approach. It does just require careful coordination about conflicting versions of the documents and which ones are signed, just to ensure that everybody is working towards the same executed document. Here in the construction team at M&R, we insist that the party who signs electronically signs first, and then the document is then printed and prepared for wet ink signatures. That will then be printed off, signed, and the hard copy itself is the one that will be dated and completed, and that will constitute the original. And that's everything from me, and I will pass on to Della.
Thanks, Kiran. So moving on from that topic, as Stuart said earlier, execution is not always as straightforward as it should be. And as a result, the matter of execution has been before the courts on many occasions. Over the next few slides, I'm going to summarise just a few decisions of the court in relation to execution. The first of those being the case of R and HMRC. Now, this case is particularly relevant to virtual signings. And when I say virtual signings, I mean where, for example, documents are circulated for signature by email and executed remotely without the need for the parties to meet in one place to sign. Whilst DocuSign has largely done away with the need for that procedure, we appreciate that there are still people who can't or don't want to use DocuSign for any reason. And so for those people, this will be particularly relevant. Now, in relation to this case, the subject matter of it is not relevant to construction. It actually relates to an alleged tax avoidance scheme. But what is relevant is that as part of the wider issues, the court considered whether certain documents had been validly executed as deeds. The particular circumstances were that early incomplete versions of documents had been signed. Those documents had then been updated, amended and finalised, and then the original signature pages of the earlier documents had then simply been transferred over to the final versions of those documents. And in this case, the judge said that there was no authority that transfer of signature pages from earlier incomplete versions of documents to later amended final versions of documents was sufficient for the execution of a deed. And that in any event, the requirements of Section 1, the Law of Property, Miscellaneous Provisions Act 1989 had not been met, because the language of that provision provided that signature and attestation formed part of the same physical document, which it didn't in this case. Now, whilst a lot of the comments in that regard were obiter, in the case of Mercury, Mercury was subsequently applied and affirmed in the case of Bioconstruct, GmbH and Winspear. And in that case, the court held that affixing pre-signed signature pages from a different earlier draft of a deed did not constitute valid execution of the final version of the deed. Now, in response to Mercury, the Law Society published a best practice note, and you'll see the link on the slide there. It's certainly worth a read if you're not using DocuSign for the execution of documents. It contains a number of options depending on what sort of document you're signing, with option 1 being relevant for the execution of deeds. Now, if we move on to our next slide and case, as Stuart said earlier, if a document has not been validly executed as a deed, it can, in some circumstances, still take effect as a simple contract, and so have a 6-year rather than a 12-year limitation period. But what happens if one party purports to execute a document as a deed and the other as a simple contract? Can the document be both? Now, this is a question that arose in the case of McDonald Hotels Limited and Bank of Scotland PLC. Again, the subject matter of the claim is not relevant to construction. It was a claim by McDonald Hotels against Bank of Scotland relating to the alleged forced disposal of hotels. But what is relevant in relation to this case is that Bank of Scotland claimed that as it had signed a document as a simple contract, a 6-year limitation period applied to any claims brought by McDonald Hotels against Bank of Scotland under that contract. They said that McDonald's Hotels claim was therefore statute barred because it was a simple contract. The relevant cause of action had accrued after the 6-year limitation period had expired. Bank of Scotland then went further than that and said that as McDonald Hotels had executed the document as a deed, a 12-year limitation period would apply to any claims brought by Bank of Scotland under the same document. So in effect, what Bank of Scotland was saying was that the document would take effect as a deed against McDonald Hotels, but as a simple contract against Bank of Scotland. When the court looked at it, they ultimately concluded that the document was not a deed, could not be a deed. It was a simple contract. And so the court did not have to consider whether that document could take effect as a deed to one party and a simple contract against another. In coming to the conclusion that it was not a deed, the court referred again to Section 1 of the Law of Property Miscellaneous Provisions Act, which specifies 2 conditions that have to be satisfied before a multi-party document can be a deed. The first condition is that if it's clear on its face that it is intended to be a deed by all parties to it, with the emphasis on all. And secondly, if it has then been validly executed as a deed by one or more of those parties. With that in mind, the court looked at the Bank of Scotland's attestation clause and saw that it made clear that Bank of Scotland did not intend the document to be included as executed as a deed. And it therefore found that the first condition of Section 1(2) of the Law of Property Miscellaneous Provisions Act had not been satisfied, so the document could not be a deed on that basis. As I said before, because they found that the document was not a deed, the court didn't have to consider whether the document could take effect as a deed to one party in a simple contract against another. But the overture comments of the judge in this case suggest, and quite rightly in my opinion, that the answer to that question is no. And this is based on the language of Section 1(2) of the Law of Property Miscellaneous Provisions Act, which appears to have been interpreted by the judge in that case as that a document is either a deed or it's not. It cannot be both. And again, in ascertaining whether it's a deed or a simple contract, intention of the parties will be key. Now, just in relation to that point of intention of the parties being key, hold that thought because it's particularly relevant for the next case that I'm going to discuss of Lend-Lease and ACOM. And this is the final case which I'll cover today. Just before I go into the detail of this one, it's important to know that in certain circumstances, a party can be stopped from alleging that a document has not been validly executed as a deed. And this was certainly the case in Lend-Lease and ACOM. And as I said before, the intention of the parties was key in the court reaching the decision that they reached in this case. In relation to the claim which was brought by Lendlease, it related to an alleged breach by AECOM of its obligations under a contract to provide mechanical and electrical consultancy services. AECOM denied the allegations, denied that they were in breach of the terms of the contract, and argued that in any event, Lendlease's claim was statute barred. There were two grounds to AECOM's argument that Lendlease's claim was statute barred. And for the purposes of this webinar, I'll only focus on the first ground as it's relevant to execution. AECOM said that the agreement operated as a simple contract, not as a deed, and so a 6-year limitation period applied. They said that Lendlease's claim was therefore statute barred because the relevant cause of action had accrued after the 6-year limitation period had expired. And AECOM's argument was based on two factors. Firstly, AECOM's signatories had signed in the part of the execution block which asserted that the document was being executed as a deed by the affixing of AECOM's common seal in the presence of 2 directors. However, the seal had never actually been affixed to that document, and so AECOM argued that the document had not been executed as a deed. Secondly, the signatories who had signed on behalf of AECOM were not directors of AECOM. So taking into account the lack of the common seal and the fact that the signatories were not directors, AECOM's position was that the document had not been executed as a deed in accordance with Section 36A of the Companies Act 1985. Now, Section 36A of the Companies Act 1985 requires either 1, the affixing of a common seal, 2, signatures of 2 directors, or 3, the signature of 1 director and the company secretary. The court considered this issue and ultimately decided that the document was a deed, having been executed as a deed by both Lendlease and AECOM. It took into account AECOM's arguments. Firstly, on the lack of a common seal, the court said that in the particular circumstances, that didn't matter. Factors that the court took into account was that there was no evidence that it had ever been intended that a common seal would be applied. The court looked at other documents which had been signed at the parties by the parties at the same time, and there was no common seal had been applied to those documents. And the court reached the conclusion that it was clear that the signatories had simply signed in the wrong place in this particular document. The court also said that it was clear, taking into account all of the factors, that the signatory's intention was that the document would be executed as a deed. In relation to the signatories not being directors, the court also concluded that in the particular circumstances, this also did not matter. And again, relevant factors were that AECOM accepted that the signatories had authority to act as they did in signing the document, and that therefore the necessary representation on the part of AECOM and reliance on the part of Lendlease could therefore be inferred. Now that brings me to the end of the summary on the cases, other than to highlight the key takeaways from those 3 cases. I think firstly, if you are still circulating hard copy documents for execution, it's certainly worth having a read of the guidance in the Law Society's practice note, and you'll find the link to that on the previous Mercury case slide. Secondly, when you are executing your documents, if the intention is that a document will be a deed, then it should be a case of check, and then check again, that the necessary formalities have been complied with. So, for example, has it been signed in the correct place? Are we signing in the correct part of the execution block? If we're applying, if we're signing in the part of the execution block which states the common seal will be applied, make sure the common seal is applied. Is it being signed by the correct people? So if the execution block states 2 directors are signing, are the signatories statutory directors of the company? And then finally, I think as the cases we've covered and made clear, the intention of the parties is key. So does the document actually state an intention for all parties signing to execute that document as a deed? And that brings me to the end of my section.
Thanks so much, Della, and thanks, Kiran. So, Della, just to really emphasize that final point, if you look at the three cases you've mentioned, two of them very clearly are, oh my goodness me, if it doesn't comply with the absolute letter requiring it to be a deed, um, uh, um, it's not a deed. And then Lend-Lease comes along and says, actually, the key to it in that case, and I appreciate each case will depend on its own facts, was the party's intention, not just in this document, but in other documents they also executed around the same time, was that it would be a deed. And I mean, it seems that Lend-Lease is the exception. It's a sort of slightly different approach to that from the other two cases.
Yeah, and when you read the judgment, it does all seem to centre around the intention of the parties. So, in the other cases, the court were quite quick to find that documents had not been validly executed as deeds, where perhaps the appropriate intention hadn't been there. Whereas in Lend-Lease, having looked at all of the factors, it was quite clear to the court that the intention to execute it as a deed had been there. And there was one particular comment by the judge in the judgment, which said that noted and picked up on the fact that actually prior to commencement of the proceedings, ACOM hadn't raised the fact that the argument that the contract had been executed simply as a simple contract rather than a deed. And this issue, this argument had only arisen during the proceedings. So I think reading between the lines, I think the court just thought that it was a little bit of a try on by ACOM and decided in that way.
Yeah, thank you. Thank you. Right. So in the course of Kiran and Della's presentations, I've answered 19 questions. Apologies for any typos. I think the person who asked the question sees the answer, and so it might be useful just to summarize them. So, Kiran, could you just repeat? There are a number of questions of it. You've got a building contract. There's drawings and employers' requirements. The solutions are a number of envelopes or cross-referencing by another way. Is that to simplify things?
That's right. So either cross-referencing multiple envelopes and linking them all together, or making that index or schedule at the very start where it lists all the documents. Those documents don't have to be added to the DocuSign envelopes then. They could be put in a data room, and the index will just confirm that the parties have seen those documents, have downloaded copies. Further copies can be available on further request, and then that bit is signed.
Next follow-up question was slightly so electronic seals. Where are we on those? My understanding was that we don't use them in English law at the moment, or have I got that wrong?
I think there are some organisations and potentially some councils that are using
local
them.
authorities have been raised in the questions.
But I think that it's rare. I haven't come across someone using an electronic seal yet.
We have had a specific question from a university client, and that individual I will reply separately on that, but I'm not aware of any universities that have seals. I'm not aware of any of them having electronic seals. So there's also been a number of questions about witnessing and signing and all of that. So I think it's very worth stressing a number of points. There are some requirements of law as to some signatures which must be witnessed. So if you are an individual executing a deed, you must witness it. There must be a witness. The Companies Act does allow for a sole director to execute a deed. In that scenario, that signature must also be witnessed. For a lot of the other requirements, questions about powers of attorney, you have to satisfy yourselves that the organization that is executing the document is doing so in accordance with that organization's memorandum and articles if they're a company, or underlying statutes if they're a university. There's no one size fits all answer to this. So it's everyone's got to make sure that things aren't executed properly. And one of the things that we do, and Della and Kiran both mentioned it, is that we look to see whether the people who've signed it are statutory directors. Now, what do we mean by statutory directors? We mean people not with the title director, but we mean people who are listed as directors on Companies House. And one of the issues that we've had to deal with is people signing documents as director, a statutory director, after they have resigned or retired as a director. And in that scenario, there's a risk that it's not a valid document, though we come back to the Lend-Lease case that Della mentioned, which is the courts may take a lenient view. So and then dating. So a number. I so many of you just don't believe me on this, and so I'll be as absolutely clear as I can. I do not care when people have signed the document. I don't care if they signed it 10 years ago, 10 months ago, 10 days ago. You do not ever, 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 ever backdate a document. If you do so, particularly with a deed, you are committing fraud. So I know so many questions on this. You do not backdate a document. A matter of fact, the document, be it a contract or a deed, is dated on the day that it's dated. So we had a question of, the electronic signatures, and so if Kiran's managing a big DocuSign signing, and she'll have all this stuff, and it might be that 2 days later she dates the documents. She won't date the documents the dates that people signed them. She'll date them the date that she dates them. And I can't, some of these questions that people have answered are quite nuanced, and on a couple of occasions I've sort of said, this is my thought answer, not an absolute answer, but I am happy to say to everyone, and Della and Kiran will agree with me, you do not backdate documents. So any of the queries, so there's a question, is it position that the deed has not been dated? It is remedied. You date it the day that you date it. So if the deed was signed 5 years ago, but it hasn't been dated till today, you date it today, you don't date it 5 years ago. And the reason for that is it wasn't dated 5 years ago, it was dated today. God, there's loads of questions coming in. Right, yes. So do you need to check that the people who've signed the contract are authorized to do so, or can you rely on the fact that if they say they are, they are? So you can, there is the concept of ostensible authority, and there's a provision in the Companies Act that says you're entitled to assume that the document's been validly executed. For other organisations, someone asked about NHS trusts, it depends on the statutory position of the NHS trust. If you have any doubts, you are entitled to ask. Why is this relevant? Well, it comes back to the arguments that Della mentioned in the cases she was summarising, which is better to be safe now than have an argument 2, 3, 4 years down the line about whether the document was validly executed as a deed. Why may that be important? There are two key issues. One is that you get the increased limitation period from 6 to 12 years if a document's by deed. And the other thing is there are certain contracts, buying and selling real estate being an obvious one, where the documents have to be by deed. Let's have a look. Goodness me. Yeah, could you date a document on the current date but state that the parties agreed the contract started, say, a week before? So yes, you can, but you need to say that in the contract. So the way you deal with that is you have a contract which says that it started the week before. If the other party doesn't follow the internal procedure, are you then at risk for them claiming it isn't a deed down the road? Yes, you are. But it then comes back to the arguments that someone like Della would be able to raise on your behalf. So the concept of estoppel, which she raised, that's the principle of someone relying on an untrue statement of fact and then changing their position. So if the other party says we have executed this document as a deed, but then they try and say they haven't, depending on the facts, it may mean that you don't have a valid document, or it may mean that they can't deny that it is a valid document. I had a scenario where a deed had been signed by a director, but at the time the second party came to sign and for the document to be dated, the director had subsequently resigned. I rejected it to be and required it to be re-signed. Was that correct? Yes. Yeah, if a secretary was a director, answer that question. Yes. So yeah, and a number of guests from local authorities saying that they are starting to use electronic signatures, although it's been a struggle. If not using DocuSign for the execution of construction contract, can you send documents via email for signature where the parties print off the signature page, signed in Wentic, and return it to the other party via email? Can you simply refer to the other contract docs that do not to be signed by reference to USB file transfer link? So mostly yes. So if you are sending the document by email for signature, I would require them to print off the signature page in Wentic and send it back to you by post, so you had it in hard copy, and then each signatory would authorize you to then insert their signatory pages into the contract, and you could then date it, remembering that you don't backdate the document. How do you refer to other documents? Yes, we use USB file transfer links. It's all comes down to evidence. So what are you trying to do? You're trying to record beyond any doubt what things have been incorporated into the contract. Back in the day we used CD-ROM, so that seems incredibly out of date now to mention it. You can have lists of documents and drawings, but what you need is the signatories to have witnessed whatever that list is, whatever that USB is, with sufficient clarity so that everyone knows what documents have been in, imported. I think I've answered anything. Daft question, but is there a difference between a contract and an agreement? No, they're two sides for the same thing. So, although a contract has a specific meaning in law. So, for example, if you reach an agreement with a family member that you will do something, that agreement is not a contract because there's no assumption that as between family members, there was an intention for the parties to create legal relations. So I suppose there can be a different, an agreement that's binding at law is a contract. Other agreements may not be binding at law, in which case they're not contracts, but they are agreements. If both parties are signed, but let's say it's never dated for 5 years, what is the risk? Well, you've got a contract underhand. How do you get around that? You date it arguably before the expiry of the 6-year period, and then you've got a deed. I think I have answered every question. So the last one was from Richard at 4:50. So I think I've answered anything. If anyone thinks you've asked a question but you haven't answered, do please email. 250 of you stayed on for the in-depth discussion on the complexities of a deed. So thank you very much for that. I'd like to thank Kiran and Della for all their hard work for explaining things, and for Sarah, who's doing all the heavy lifting in the background that you can't see. we would appreciate some feedback, and you'll get a link to giving feedback at the end of this, and it will give you the opportunity to ask for some webinars on other things. The next webinar that we have planned is by our more junior team members on, I think it's something along the lines of 10 things about construction contracts that you should really know. So I'd like to thank you all very much for your time and for your participation and for the questions, and wish you all what I hope is a sunny afternoon. It's certainly sunny in Birmingham, and I'm going to look forward to spending some time in the garden. Thanks so much. Bye.